Good morning. Hi, my name is Mike Khalilpour, and I'm a senior associate at the Green Law Group here in Simi Valley and head of the estate planning practice. Before we begin, just to let you know that this webinar is general information and educational in nature only, and for your specific matters, please be sure to speak with an experienced estate planning attorney. You don't have to take anything I'm saying today as gospel or the only way to do things, since the law does tend to change on a regular basis. And so what is true today might not be true tomorrow. There may also be exceptions to the general rules that would apply to your particular situation. This is designed solely to be background information to help facilitate the conversation and probably multiple conversations that you want to start having. Today's webinar is all about how and why to avoid probate and estate planning, which I believe is one of the most important steps any person can take to make sure their final property and healthcare wishes are honored and that their loved ones are provided for in their absence. First question that arises is, what is probate? Probate is a legal process that takes place when after someone dies. Make sure property and possessions are given to the correct people, and any taxes or debts owed are paid in full. There's a written will, court checks to make sure that it is signed and witnessed correctly and is otherwise valid will, and then make sure the directions in the will are carried out. If you pass without a will, court will follow the state's testate laws to figure out how and to whom to distribute your property. The next question that often comes up is, what property is subject to probate? Typically, it's assets in your sole name, such as bank accounts, real estate, cash, securities, and vehicles, any personal property that you own, such as jewelry or furniture, and any kind of account that you have for which you have not designated a beneficiary. And that can include retirement accounts such as 401ks and 403bs, in addition to life insurance if the proper beneficiary designations have not been made. Properties not subject to probate are those typically that are jointly owned assets, such as joint bank accounts, jointly owned real estate securities, and any account or asset that has a proper beneficiary designation. Typically, life insurance policies have beneficiary designations, and retirement accounts, you also have the option of having a beneficiary designation. Lastly, assets held in a living trust are not subject to probate. The next question is, why should I care and why do you want to avoid probate? There's really three main reasons you want to avoid probate. First is time. It can often take several years, several months or years to probate an estate after someone's passing. Second reason, money. It's often very expensive to probate an estate, both in terms of attorney's fees and court costs, which function typically as a percentage of the gross value of the estate. And lastly, it's privacy. Probate is a court process, and with most court processes, all documents filed with the court are public record and open to the public. So now the question arises, well, how should I avoid probate? Simple answer, estate planning. Now, you might be thinking that estate planning is only something that high net worth individuals need. But nowadays, all individuals need to plan for when something happens to them. Even if you're only leaving behind a primary residence, if you don't decide who receives the property when you pass, you don't have any control over what happens to it. The main component of estate planning is designating heirs to your assets. Without an estate plan, the courts will often decide who gets what. Process, like we said earlier, can take years and is expensive and has the potential to be both a public and an ugly fight. Secondary component to estate planning is making sure that your small children are taken care of based on your own wishes. Nobody thinks of dying young, but if you're the parent of a small children, you need to prepare for the unthinkable. Third component is being able to plan and minimize any estate taxes, or sometimes called death taxes, that might be owed to the federal government. Estate planning is all about protecting your loved ones, which means in part giving them protection from the IRS. Essential to an estate plan is is transferring assets to heirs with an eye on creating the smallest possible tax burden for them. Without a plan, the amount your heirs will owe Uncle Sam could be quite a lot. One thing we've learned is that the tax code can be changed drastically at any given time. Finally, having a comprehensive estate plan eliminates family messes. All heard the horror stories. Someone with money dies, and the war between family members begins. One sibling may think they deserve more than another, or one sibling may think they should be in charge of the finances, even though they're notorious for racking up debt. Such squabbling can get ugly and end up in court, with family members pitted against each other. Stopping fights before they start is yet another reason why an estate plan is necessary. This will enable you to choose who controls your assets and finances if you become mentally incapacitated or after you die, and will go a long way towards quelling any family strife and ensuring that your assets are handled in a way that you intended. Will also help you make individualized plans if necessary to arrange for a child with health problems, or to set up a trust for one who might be better off not inheriting a lump sum. Could also help you give more to the child who did most of the work for caring for you in the later years, or less to the one whose extensive education you funded while paying far less to their siblings. Deciding whether to divide your estate exactly equally is one of the key tasks you need to think about. And of course, if you have more than one spouse or have children from more than one family, an estate plan is urgent. Now, typical estate planning documents are common documents that are part of an estate plan. One is called the last will and testament. Will is the document that provides instructions on how your property and custody of minor children should be handled after your death. It is written to express your wishes and names an executor of your estate that you trust to fulfill those stated intentions. The will can also create a trust after death, or if a trust has already been created, disposition of any property or assets that were not already transferred into the trust. To ensure that your children are cared for in a manner in which you approve, you can also name guardians in the event that both parents die before the child turns 18. Without a will to name these guardians, the courts typically step in and decide who will raise your children. While this is arguably one of the most important documents in the estate, this by itself does not avoid probate. Next common document in an estate plan is called a healthcare directive. Advanced healthcare or advanced medical directive is the document that explains how you want your medical decisions to be made if you cannot make those yourself. An advanced directive lets your healthcare team and loved ones know what kind of healthcare you want or who you want to make the decisions for you when you cannot. An advanced directive can help you think ahead of time about the kind of care you want. It may also help guide your loved ones and healthcare team in making clear decisions about your health when you can't do so yourself. These medical decisions may include special instructions or emergency care from your health team and can specify do not resuscitate decisions that have been made and can address things like organ donation wishes. Advanced directives only apply to healthcare decisions and do not affect financial or money matters. Next document that's typical in an estate plan is the durable power of attorney or the power of attorney. A durable power of attorney is a legal document and gives someone you choose the power to act in your place. In case you ever become mentally incapacitated, you'll need what is known as a durable power of attorney for finances and other business affairs. A durable power of attorney simply means that the document stays in effect if you become incapacitated and unable to handle your own matters. With a valid power of attorney, the trusted person you name will be legally permitted to take care of important matters for you, for example, such as paying your bills, managing your investments, and filing or signing your tax returns if you're unable to do so yourself. Lastly, one of the common documents in an estate plan is what's referred to as a revocable trust or a living trust, or sometimes it's referred to as a family trust. At its most basic level, a revocable trust is a private written document that determines how your assets will be handled after you pass away. These assets can include real estate, valuable possessions, bank accounts, and other investments. As with all living trusts, you create it during your lifetime, and assets you place in the trust are then transferred to your designated beneficiaries upon your death. What sets the revocable trust apart is that you can change or cancel provisions at any time, hence the term revocable. Living trust also allows you the flexibility and control in how and when assets are going to be distributed, and it can help protect assets from debts of a beneficiary. Also, since living trusts are private documents, assets placed in the trust and distributed do not go through probate. Living trust also provides flexibility for estate planning and savings, especially for married couples. Coupled with a pour-over will, these two documents can serve as your primary estate planning documents. Taking the time to make these documents is well worth the small effort it will take. We are here to help if you have any questions or want help drafting any of the documents mentioned in this webinar. Please do not hesitate to contact our office. This concludes our live webinar for today. I will be happy to answer any questions that you have. Okay, seeing as how there's no questions, thank you for your time.